and welcome back to Chapter 8, Module 6. I will be covering all the chapters in this module. Well, I'll call this Module 6 Part 1, just in case if I run out of time. Thank you. We talked about some terms you should know. Please be familiar with all these terms: consent, durable power of attorney, duty, HIPAA, injury, malpractice, negligence, private law, public law, standard of care. Thank you. In the introduction, nurses must know the basic laws and confirm their practice falls within sound barriers. We talked about all the different type of negligence and malpractice and doing the right thing. As you review this slide, I want you all to make sure you go to page 78 and review box 6-2, American Nurses Association Standards of Practice for Gerontological Nursing. It provides a guidelines for gero nurses that offer descriptions of what is considered safe and effective care. As you look at this slide, don't forget about home health agencies. They also fall under public law. You can find that on page 106, 9th edition. Private laws govern relationships among individuals or between individuals and organizations and involves contracts or torts. Let's see, for example, wrongful acts against another party, including assault, battery, false, imprisonments, and invasion of privacy. These laws protect individual rights and also set the standard of conduct. Oh, my apologies. As you look at this slide, legal risk in gerontological nursing, look at the bullet points as I speak. Now know that repeated episodes of careless can happen, but also the one-time deviation from standards can result in serious legal problems. Look at box 8-1, acts that could result in legal liability for nurses. Make sure you look at those boxes so we can continue to work on the standards of care and fall within our standards so we cannot be in any wrongdoing and patients can continue the trust that they have for us. Now, as we focus on malpractice, I would like for you to look at each of these bullet points. I won't read them out to you, but please read each of those bullet points. Look at some examples on malpractice. Look at page 106 at the bottom of the page. It gives 4 examples. Those examples are deviation from the standard of care, which makes the nurse liable for malpractice. Now, when we look at duty, it's the relationship between the nurse and the patient, which the nurse has assumed responsibility of care of that patient. Negligence, failure to conform to the standard of care. However, as we did lecture, I gave some of you some examples of negligence. Let's not forget about injury. Injury, physical or mental harm to the patient or violation of the patient's rights resulting from negligent act. Okay? Duty, negligence, and injury must be present for malpractice to exist. Please don't forget about what we spoke of in class regarding malpractice. Remember, we talked about delegation of responsibilities, making sure we follow up on that person who we delegate to, making sure we give them direct actions or just giving them directions and saying, hey, take the blood pressure in room 29A and please come back to me with the results. Please let me know if there's any abnormal lab results. Those things are all part of your delegation and making sure that person is responsible and they're capable of knowing how to do a specific task that you have them to do. Increased responsibilities accompanied by increased risk of malpractice. So some of the charge nurses at the facilities we go to have that increased risk because they're not only over the CNAs, they're over the LVNs also. So be aware of risk in practice and be proactive in preventing malpractice. Nurses should carry your own malpractice insurance. So we all carry our own. The hospitals have insurance to help protect you, but sometimes the legal ramifications and the costs are over and beyond what the hospital is covering us for. So it's always good to have your own malpractice insurance as well. This slide reviews some situations that may result in negligence. Look at each bullet point. This is also on page 108 on the right side of the page. Look at box 8-2, recommendations for reducing the risk of malpractice. Now, we all know about confidentiality. Want to make sure that you are aware of the Health Insurance Portability and Accountability Act. So, patients have access to the medical records. We do. We can ask for a copy of our medical records. Patients have control over how personal health information is used. Other provisions, patients can ask their providers to change incorrect information that they have discovered in their record or to add missing information. Hey, I have a history of a broken femur back when I was 16. That doctor wasn't aware of that. They also can request that their health information not be shared. Okay, way back, Congress authorized civil and criminal penalties for covered entities that misuse personal health information. All claims submitted to Medi-Cal is done electronically now. Let's make sure that whatever facility that we're learning in, or that we graduated and got our RN and that we're working in, that we know the policies and procedures of that facility, of that particular floor, and also know your patient's privacy. Hey, as you guys look over patient consent, did you know that if no consent prior to a medical or surgical procedure, it can be considered battery? Look on page 109. When in doubt, please obtain a consent. Consents must be informed. Look at page 109. It is important for the patient to have been informed of their consents, their rights, before any medical or surgical procedure. A written consent form should describe the procedure, its purpose, alternatives to the procedure, expected consequences, and risk. Remember when we talked about in class about the nurses and consents? So a nurse should not be in a position of obtaining consent for the physician because it's illegal and because they may not be able to answer some of the medical questions. So we need to make sure the doctor is doing that. When consent is being obtained, nurses should assess if the patient or his or her representative fully understand the procedure, its purpose, alternative, expected consequences, and risks. If they're having questions, comments, or body language like kind of indicate like, I don't really understand what's going on, the nurse should ask if there are any questions or if more information is needed, and to ensure the need is addressed. Please review the elements of an informed consent. Written description of the procedure and its purpose, explanation of the person performing the procedure, alternatives to the procedure. It's all on your consent when the patient is signing a consent. Expected consequences and risks, signature of the patient, gotta have a witness, and make sure it's dated. Now, I know that we all know that patients who are mentally incompetent, they cannot give consent. Next of kin may not be a legal guardian and may not be able to give consent. Okay, now when you go to court, the court appoints who's the legal guardianship, and there's all different types of appointees that the court can do. So definitely the family member would have to show paperwork or documentation from the court. As you look at this slide, I wanted to reinforce what I said earlier, and you can also find information on page 111 that gerontological nursing, they are responsible for supervising other staff, may They may be licensed or unlicensed personnel. In these situations, nurses are responsible for not only for their own actions, but also for the actions of the staff they're supervising. So this falls under what used to be called doctrine of respondent superior. Let the master answer. So nurses need to basically ensure that those caregivers whom they are delegating are competent to perform the task and carry out their assignments properly. With the medications, you want to make sure that you don't miss any of your rights and don't do any bending, side swiping, corner cutting, any of that. Stay within your scope of practice. As you review this slide, I want you also to look at page 112 for specifics on restraints. The Omnibus Budget Reconciliation Act, OBRA, imposes strict standards on use of restraints, both chemical and physical. Even we do not restrain patients to wheelchairs. If you notice in the skilled facilities or the subacute, we have bed paddings on the floor. No 4 side rails are up. A physician has to come and reassess that patient within 24 hours. There also has to have a policy written for the staff to abide by. In today's time, we do try to avoid telephone orders, but the most important thing as you read this is to make sure that you do a complete read back on your order that the doctor is giving you over the phone if you're in such a situation that still does telephone orders. In geriatric nursing or gerontological nursing, remember there is a high caseload of terminally ill patients. Make sure that you know the order, the do not resuscitate order, and it does have a physician signature on it. And a consent must be obtained. The agency should have a policy about do not resuscitate and where to find a policy. As we talk about advanced directives, and issues related to death and dying, this slide is advanced directives and issues related to death and dying. I know that the header is cut off and I couldn't bring it down, so I do apologize. But just know that advanced directives express patients' desires for terminally care, life-sustaining measures. Patient Self-Determination Act requires health care facilities to ask patient about advanced directives. States vary in use and types of advanced directives. So know which state you're in, how the laws are operated, and you can go on with your advanced directives. Just know that a consent for autopsy must be obtained except in cases of criminal act, malpractice, and occupational disease. So know that if a patient passes away, if it's considered a coroner's case or one of these down below, sometimes consent, the coroner kind of supersedes. But remember, consent for autopsy must be obtained. Consent in cases, except in these cases. Okay? Nurses should not be the legal witness to a will. Should not. And also, pronouncement of death falls within the scope of medical, not nursing. Please don't forget about elder abuse. Caregiver stress can lead to abuse. All of the stress that they do in turning, repositioning, feeding, bathing, giving medication, feeding, cooking, cleaning, every day, it can lead to stress, which can lead to abuse. So they do need to have a timeout. Elder abuse can be physical, emotional, sexual exploitation, neglect, and or abandonment. So make sure that we are doing really good assessments on our patient. Some of the indications of possible abuse or neglect includes malnutrition, dehydration, among others. And you guys mentioned some in class, how they stay alone or get feared when someone comes around. Nurses have legal responsibility to report abuse. As you read this last slide of Chapter 8, Legal Safeguards for Nursing, and all the bullet points, I want to say thank you, and please stay tuned for Part 2 of Module 6, and I will be covering Chapter 9. I will try and get 2 chapters in there, but let's see how I can do all of this in 15 minutes for you. Okay, well, you take care, and I'll see you on Part 2, Module 6.